Planning is now in session. Please.
Good morning. I hope everyone had a great weekend. Welcome to the First District Court of Appeals. Today is Monday, April 14th, and we currently have 5 cases on today's docket. Only 2 will be arguing this morning. So the first case we have has submitted on the briefs, and that is case number C240537, State ex rel. Joseph Frazier versus City of Wyoming Police Department et al. The next case we have is scheduled to argue, so if attorneys can please identify themselves and the readiness to proceed, and that is case number C240386, Deborah Worley, Administrator of the Estate of Faye Roseberry versus Dr. Durrani et al.
Good morning, Your Honor. Annie McClellan on behalf of the appellants, and I'm ready to proceed.
Good morning.
Alan Stabman and Ben Moran on behalf of the plaintiff lead, and we're ready to go.
Okay, thank you. The next case we have has submitted on the briefs, and that's cases number C250045-060, In Re AS. The next case we have is going to be arguing this morning. It's cases number C240560-561-562, In Re DL.
Good morning, Your Honor. Margaret Kane on behalf of the defendant appellant DL. Thank you. Ready to proceed.
Norman Wessex on behalf of the state of Ohio, the appellate, we're ready to proceed.
Okay, good morning. And the last case we have has submitted on the briefs, which is case number C240515, State of Ohio versus Michael Coleman. Attorney McClellan, good morning again. If you can come on forward. Did you have a good weekend?
Yes, thank you, Your Honor. Did you?
It was good, it was good. We're having sort of crazy weather, aren't we?
Amen.
Mother Nature just can't make up her mind.
Hopefully soon enough.
Would you like to reserve time?
Yes, Your Honor. 3 minutes, please.
All right, you can start whenever you're ready.
Thank you. Good morning, Your Honors, and may it please the court. My name is Annie McClellan, and I represent Dr. Durrani and Cast. This is one of the easier Dr. Durrani cases for this court to decide. That's because this court has already said that the issues that occurred in this case, playing the Dr. Durrani collage and allowing license revocation testimony, are errors. The court has said as much in cases like Stevenson, Green, Mann, Nayhouse, and Honchel v. Durrani. So the question here is not whether the trial court erred. You've already said that it has. Instead, the question is whether those errors affected the outcome of the trial. And here, the answer to that is yes. These errors were not harmless for 3 reasons. First, this is one of those quintessentially close cases that could have gone either way, the language used in Green versus Durrani. Second, there was competing expert testimony. And third, the plaintiff's counsel highlighted these prejudicial statements and the Durrani collage itself in the closing argument. We know in part that this was a close case because of the non-unanimous jury verdict.
I really just have one question, honestly.
Yes, Your Honor.
Maybe I have more than one, but at the onset I have one. As I read your briefs, it seemed to me that really what you were arguing was cumulative error, more so than error on each one of these matters in itself.
Your Honor, we would...
At least that's the way the brief seemed to present itself.
Your Honor, we would argue that each individual error was not harmless in and of itself as well. There are only the 2 here, really, the Durrani collage and the license revocations, which are very much intertwined, and that's part of
Right,
why
because
you read
the
that.
licensing revocation is part of the collage.
Yes, and for the cases that have found that license revocations are not harmless, the Durrani collage was played. And so we would argue that all of these errors are not harmless, the playing of the Durrani collage and the references to the license revocations, but the cumulative aspect as well, of course, necessitates a new trial.
So how is the collage presented? Is it presented at, does the plaintiffs, do they talk about it from the very start in terms of, we're going to play this, or is it just presented as a part of the trial? What is the mechanics of that?
In this trial here, there's reference to Dr. Durrani not being present to testify, of course, and that you would hear from him via deposition. And so that is how it was portrayed, was a video deposition, different spliced and parts of different depositions put together, and that video was played for the jury.
And in terms of that presentation, when it is to be played, was there an objection that was lodged at that moment?
Your Honor, there were objections along the way. The Durrani litigation as a whole, and this is part of our supplementation of the record, has dealt with the Durrani Collage very early on. And so we submitted a supplementation to the record explaining how we preserved that objection along the way in all of these trials. So before the moment of the Dr. Durrani Collage being played, those objections have been preserved long before and continue throughout.
All right, thank you.
Another reason we know this was a quintessentially close case was because of the fraudulent misrepresentation claim in particular. Dr. Durrani was found to be liable for fraudulent misrepresentation, and the jury apportioned 50% of the damages to that fraudulent misrepresentation claim. And so a fraudulent misrepresentation claim obviously looks to whether Dr. Durrani deceived Ms. Roseberry or otherwise lied to her about the surgery that she needed. And so for the jury to award 50% for that fraudulent misrepresentation claim suggests that the jury really did rely on that Durrani Collage testimony and look to what was said in that Durrani Collage to show that he was a liar. Plus, the jury here awarded punitive damages, and again, that suggests that they wanted to punish Dr. Durrani, again, having seen the Durrani Collage before them.
Was this a unanimous verdict?
No, Your Honor. It was 6-2 for the negligence and fraudulent misrepresentation claims, and then 7-1 for the lack of informed consent claim.
Okay.
What's more, all of the not all, but many of the experts in this case agreed that Dr. Durrani needed or Ms. Roseberry needed some form of surgery. They just disagreed on exactly what type. So you have plaintiff's experts such as Dr. Wilkie and Dr. Bloomfield testifying that yes, she needed some help. She was in such a degree of pain and had experienced an 8 out of 10 back pain, 10 out of 10 leg pain for many years, suffered for nearly a decade before, that she needed some assistance. And so they just disagreed on the type of surgery specifically. Dr. Wilkie and Dr. Bloomfield both said there should have been a decompression surgery, and Dr. Wilkie also testified that she needed an L5-S1 fusion, but they just disagreed that Dr. Durrani should have done more than that.
So everybody, all of the experts on both sides agreed there should have been a surgery?
Nearly all, Your Honor, the ones who were able to testify to whether there should have been a surgery.
Okay.
Your Honor, as for competing testimony, we have the plaintiff's experts not really able to agree here on some of the core issues. Dr. Sani was the only expert who testified regarding a fracture in this case, and no other expert testified that they had seen a fracture. You also have Dr. Wilkie, again, a plaintiff's expert, testifying that he saw neurogenic claudication. And Dr. Bloomfield, another plaintiff's expert, didn't see that. So you have the plaintiff's experts disagreeing among themselves. And of course, the plaintiff's experts also disagreed with the defense experts on the core issues of this case as to whether the surgery was indicated. And finally, Your Honors, plaintiff's counsel highlighted the Durrani Collage for 4 pages during the closing argument transcript. It was incredibly important to the plaintiff that the jury rely on the collage, particularly for that fraudulent misrepresentation claim. Within those 4 pages of the closing argument, plaintiff's counsel highlights Dr. Durrani as a liar or references lying 5 different times. And he points to other medical malpractice lawsuits, the criminal charges, the unpaid legal fees, the exact testimony that was brought up in the Durrani Collage. And that's at 1939 of the transcript. Finally, Your Honors, again, in looking at harmlessness here and whether these errors were harmless or not, this court has also considered things like pre-existing conditions, as well as some level of success of the surgery. And here, we had seen Ms. Roseberry had many pre-existing conditions beforehand. A tear in her back, she had osteoarthritis, osteoporosis, she had to use oxygen, she had COPD, she struggled to get around long before she even saw Dr. Durrani. Now, aside from the Durrani Collage and the license revocations, we'd also ask that you consider the permanent functional disability here and find that there was no such thing. The statute requires a permanent or substantial physical deformity in order to find a catastrophic injury necessitating a higher damages cap. that can include a loss of a limb or some sort of loss of bodily function, a bodily organ system. And frankly, Your Honors, that's not what happened here at all. Miss Roseberry suffered from the get-go. She could not walk around. She needed Deborah, her daughter, to help her around the house. She had to use a cane in order to get from one place to another, and she needed assistance with all aspects of her life, frankly. And so for that reason, we would ask that you consider the high standard, the other case law that find that catastrophic injury is so much worse such that you can no longer do life-sustaining activities or perform life-sustaining activities.
Was there an interrogatory on the catastrophic injury?
Yes, Your Honor.
And what did
Oh, I'm
the-
sorry, yes, there was
What did the jury say was the catastrophic injury?
there was a jury award, I'm sorry, there was not an interrogatory where they listed
Was
what
there,
was the reason.
was there a request for an identification of the catastrophic injury?
Not to my knowledge, Your Honor. And finally, Your Honors, if nothing else, we ask that you find set-off in this case. Plaintiff's counsel ignores the McCann case in their brief, and McCann is exactly on point here. 50% of the unintentional tort should require the diminishment of the compensatory damages here. Coincidentally, it was the exact same percentage in McCann as it is here, 50%. That went to unintentional torts. And so for that reason, we would ask that, at the very least, you find set-off as necessary.
Did the counsel below, did they argue for a 50% split of the damages, or is that simply a coincidence?
It's a coincidence, Your Honor, that the jury allocated to 50%. And for all those reasons, Your Honor, we ask that you vacate and remand for a new trial, and I'd like to reserve the rest of my time for rebuttal.
All right, thank you. Good morning.
Morning. I've learned after 124 trials, most of with Judge Reese, who was a general, well, he was just about to become a general in the Army when his wife got transferred to Indonesia and followed her, that I don't stand up until I'm permitted to by the court. So
That's okay.
why I'm waiting.
How are you doing? How are you doing this morning, Attorney
I'm doing
Statman?
all right.
I hope you enjoyed your weekend.
In the famous words of a one-armed car wholesaler from Swainsboro, Georgia, when he got up to pick the jury in a case against me representing himself, he looked at the jury and said, "Y'all know me? Y'all know me." So, y'all know me
All righty.
at this point. So, I really have to start out, and I've said this to the court many times. The problem with these appeals is the fact that these lawyers aren't at the trial and don't understand the medicine. So, for instance, you just heard she had a tear in her back. Well, no, she had a tear in the annular fibrosis of a single disc, which is often seen with a bulging or herniated disc, regardless of your age. And those are not always treated with surgery. They talk about it was a spinal surgery, fusion surgery, screwing together the parts of her spine. That's not how this works. When you decide to go to the ultimate solution, if a surgery is going to be performed, you do a spinal fusion. The screws are used to stabilize the rods, and that whole construct is done to stabilize the spine while a fusion occurs over a 6 to 12 month period of time. The screws and rods are there to hold it still so that the fusion material, which can be either a cadaver bone or a bone morphogenic protein or harvested bone from your crest of the iliac portion of your pelvis, builds new bone and fuses those two together. The hardware then becomes completely superfluous.
Would you, I think it seemed like what they were trying to say is that experts from both sides agreed that some type of surgery was warranted.
No, what the experts on our side said that no surgery was warranted, but if a surgery was going to be performed, they wouldn't have taken issue with a completely different, less invasive kind of surgery, which is a decompression of the nerve root.
So just so I'm understanding, your experts said that in their opinion, there was no surgery warranted, but if there would be a surgery, this was the wrong one.
Correct.
Okay.
That the surgery, and the jury found specifically that the surgery was unwarranted, and I will get to that. They point out that the surgery was performed perfectly. Nobody is questioning technique in these cases. You can, if I don't have a broken arm, but somebody tells me I do, and the surgeon performs a perfect surgery for a broken arm, okay, he's operated on my perfectly normal arm and did a perfect broken arm surgery. The issue is whether the surgery was warranted, not how well it was performed. And then they talk about, she also continued to smoke over a pack of cigarettes a day, which causes back problems. That's also a completely false misrepresentation of the medicine. She did smoke, and smoking was one of the reasons the jury found lack of informed consent. What is required of a doctor if you have a heavy smoker is that in the informed consent process, you tell the patient they need to stop smoking for up to 6 months, not because it's causing their back problems, but it interferes with that fusion that I told you taking place. There are chemicals, and it's not nicotine, there are chemicals that come from smoking that directly interact in a negative way with bone morphogenic proteins, with the cadaver bone or the harvested bone, and can cause what's called pseudoarthrosis, which is non-union.
So it seems to me that obviously, in regards to the experts, there could be all sorts of esoteric, or not even esoteric in the context of your knowledge, medical testimony below. But when you know you have these rulings regarding the collage that pre-exist, why even risk playing the collage?
They did not exist at the time of this trial.
Okay.
And as soon as we got the first ruling, we stopped using the collage.
So this is in the interim when you didn't know that the collage was going to be impermissible.
Correct.
So how do you overcome that case law then in this circumstance?
The Bender case decided by this court, which has exactly the same facts, and the judges that decided that case found harmless error. And they cite the Bender case. They just failed to tell the court that it was a quote-unquote close call with jurors deciding for and against the plaintiff and other issues. But see, what's interesting about this case is if you look at the descriptions, what was the negligence the jury found? What was the malpractice? They never talk about the collage or his lack of a medical license. They talk specifically about the medicine. And one of the things they find, which falls right back into this issue of
But
smoking.
isn't that exactly what their point is, that the collage would have tainted how they saw the evidence on the medicine?
I don't think so, because if you look at their decision on fraud, they explain that as well. And they found that the surgery was unwarranted, which didn't come from the collage, it came from what our experts said. These cases, in some level, turn into a battle of the experts. And we know, quite frankly, going back to your question of the collage, that it got used in a number of early cases. Then it stopped. And there are over 70 verdicts without collages in favor of the plaintiffs. You were not here a couple weeks ago. We've tried 124 cases. We win 82% of the time since my coming into the litigation in the first trial being June of 2018. And since the retrials where it was found that there was some error we have won, I can't remember if it's 7 out of 9 or 8 out of 9, without the quote-unquote tainted evidence.
But we
So-
can't consider that information,
Okay.
right? So I guess on the basis of this record, what is your harmlessness, or your argument that this was harmless?
The evidence was overwhelming for his malpractice. He told her he would fix her. He didn't. He didn't fill out the informed consent forms. You don't need a collage to find lack of informed consent when you have a patient sign a blank consent form 2 times.
Can you argue the evidence is overwhelming when you don't have a unanimous jury verdict?
There are always people that see things differently with the same evidence. I've had 6 out of 8, 7 out of 8, 8 out of 8.
I understand
I
that,
don't-
but I mean, how do you argue it's overwhelming when you have,
Bender, your decision in Bender,
and that was a non-unanimous?
6 out of 8, as I recall, was not a unanimous verdict, and you found exactly in opposite to how they're arguing? I mean, that's what I look at, and that's going to come back to not me trying to go tit for tat about each page of the transcript. That's going to come from you reading it as if you were a juror and coming to your own conclusion as to whether the evidence was overwhelming or whether it was tainted by this cumulative error. I don't see any
wanna
other
make
way
sure-
around
make
it,
sure I-
given the Bender decision.
I want to make sure I understand something, okay?
I'm sorry, I couldn't hear you.
That's okay. I want to make sure I understand something. I want to be 100% clear on this. So your position isn't that the surgery made her worse?
It may what?
Your position is not that the surgery made her worse, made her conditions worse?
Oh, no, my position is it also made her worse. And
Because you
that's why
talked
the-
about that he had asserted that he would fix her. So your position is it made her worse and that he didn't do what he claimed he would be able to do, which is to
Right.
fix her.
And the jury found it made her worse because they checked the box for catastrophic injury, and I can read.
Do you, in regard to catastrophic injury, do you ever ask them to identify in an interrogatory what the catastrophic injury was?
Well, there is a box they check.
But there's no specific, tell us what the catastrophic injury is? You don't do that as a matter of routine?
Well, it says that permanent physical functional injury that permanently prevented Faye Roseberry from being able to care for herself and perform life-sustaining injuries. That's what it's always been. We've never had it any different.
Okay. But it's that specific?
Yes, I just read
Yeah.
from the checked interrogatory. And there is also testimony in the record that the spine is a vital organ of the human anatomy, which is, they didn't check that box, but is an element of finding potential catastrophic injury. And the spine was permanently changed. They talk about the fact that the patient comes with numerous comorbidities. Well, that is just typical of a spine patient.
And to that point, they also talk about the assistance that she needed in her care before the surgery.
Sure.
Okay. What's the evidence of how that had somehow accelerated or exacerbated pursuant to after the surgery?
Her relatives talked about how she had gotten worse, and that's in the record. I don't have the recall to say, well, now she couldn't hold her fork the same way or whatever it might be, but there's clear evidence that she was worse following the surgery than she was before she ever had the surgery.
Because they seem to rely in their briefs with quite a bit on those pre-existing both conditions and need of care. At least that's the way that I understood the briefs. And so with regard to the pre-existing medical issues that she had and also her propensity to smoke, which was argued in the brief as causing back problems, which you already noted in your argument, was there any evidence to support that those medical conditions contributed to the back in any way?
that her pre-existing medical conditions contributed to her post-surgical conditions?
Contributed to both the pre and the post, because they would have been
Well-
existed both before and after.
Well, you don't come to an orthopedic spine surgery for preventative care. So virtually everyone that comes to an orthopedic spine surgeon has a list of problems that are pre-existing. It could be prior surgeries from years past that may be causing them problems. It could be loose hardware from prior surgeries. It could be they had no surgeries, but 10 years ago they were in an auto accident and always had mild back pain, and now it's progressed to where they can't take the pain anymore. So I would say that anybody that comes to a spine surgeon has comorbidities and problems that are leading them to seek, in this case, Dr. Durrani's assistance. And Dr. Durrani had a habit of telling the patient, as he did in this case, I will fix you. Fix you. Not, I'll make you feel a little better. We can't solve these problems completely. I will fix you. And so a lot of that, I think, goes by the wayside. And you can look at specifically what the jury says about the negligence and the fraud. And they talk about the fact that the surgery was not necessary, that there wasn't proper informed consent, and that he fraudulently induced her to have an unnecessary surgery, and they explain that in an interrogatory, specifically in their own hand. So I think that there is, like Bender, enough evidence to get past the fact that this jury never mentions in the things they write, oh, well, he didn't have a medical license 2 years later, and that's a reason we find what we find. Or that something from the collage, the fact that during his residency he had been sued or named as a defendant a number of times, had some influence on their verdict. They are told specifically what they're allowed to
Attorney Statman, you have about a minute left, just to let you know.
They're told exactly what they're allowed to consider from his absence, which is very, very narrow. The last thing I'd like to mention is this idea of this 50-50 split. As these appeals come up, and as some of them have been argued, you don't see that anymore. The reason you don't see that is because you can't divide an indivisible injury. Whether you got injured because of fraud or you got injured because of negligence, your injury is your injury. There may be multiple causes that produce the same injury, but the injury is the injury. And you see no appeal on that issue from either side, and that is no longer an interrogatory in these cases because you can't divide up what part of my broken arm came from fraud and did this part come from negligence. It's an indivisible injury. And where there's fraud found, there shouldn't be set-off. The doctor should not get the benefit of set-off where a jury has found fraudulent conduct. Thank you.
Thank you.
Your Honors, I'd like to respond to 3 points that Plaintiff's Counsel made. First, there was no jury interrogatory on the catastrophic injury question. There was only an interrogatory on the negligence finding. So the jury did not give a reason for why they found catastrophic injury. They did not give a jury finding as to why they found for fraudulent misrepresentation. So there wasn't an opportunity for them to have cited something like the Durrani collage and all of the lies and deceit that purportedly came through. In addition, this case is nothing like the Bender case, as I know Your Honor, Judge Zayas is familiar. In that case, that was an experimental surgery on a 13-year-old who had conservative treatment work before the surgery. She had a back brace, I believe, that was working beforehand. This case is nothing like that and far more in line with Mahan versus Durrani, which is a case in which this court reversed. I believe Judge Krause was on that case. This is a that was a case where the court reversed solely for playing the Durrani collage, and they found that that error was not harmless, based again on the testimony during closing, some of the improvement of plaintiff after the surgery, and also the competing expert testimony. And finally, Your Honors, the plaintiff's arguments about the surgery do not matter for the harmlessness analysis at all, or the references to the back in particular. Again, this was a surgery that several plaintiff's experts testified was not necessary to that same degree, but they testified that she should have had some sort of surgery, or some sort of surgery could have worked better for her.
And there didn't seem to be consensus on what that surgery would be.
Absolutely, Your Honor.
And I just find that interesting, because obviously different doctors can have different opinions as to what the right course of action is. So that would be something that I would think the jury would be considering. One thing that I'm very curious about is you seem to rely a lot on maybe pre-existing conditions is the wrong term, but that she was a smoker, all these different things that she had going on in her life before the surgery.
Yes, Your Honor.
And particularly with the smoking, what in the record is tying that to her back?
There's evidence that there was suggestion that the smoking would have suggested she shouldn't have had a surgery at all, but that is important because many of the experts testified that she still needed some sort of surgery or should have had some sort of surgery. In addition, it emphasizes that she would have struggled to recuperate in the same way that a non-smoker may have been able to recover, and so that would have caused her problems after the fact as well.
Okay. Because I'm not sure you parsed that out in your brief, and I read it differently. I read it as if you were saying, well, she's got these conditions, and so, including smoking, I don't know if that's a condition, but circumstances. She has these circumstances, and, that, I don't know, it read to me quite differently than that.
Well, Your Honor, I would also argue that the pain that she experienced specifically related to the back just exasperated that much more of all of her circumstances around. She had the 8 out of 10 back pain before surgery, the 10 out of 10 leg pain before surgery. There were plenty of indicators before the surgery as well that led to believe that she needed some sort of help. This was truly a last resort, and Dr. Durrani was her last hope. And for those reasons, Your Honor, we would ask that you vacate the judgment and remand for a new trial. Thank you.
I'm going to make sure there's no other questions from the panel. All right, thank you. Thank you both for your arguments this morning. We'll take the matter into submission and issue a timely decision. I hope you have a wonderful week. Good morning.
Good morning, Your Honors.
How are you doing this morning?
Doing well. How are you, Your Honor?
Good. I am good. I'm really good. I hope you had a good weekend.
I did. Thank you.
You can start whenever you're ready.
All right, and I would like to reserve 3 minutes,
Alrighty.
please. Good morning, Your Honors, counsel. May it please the court. The central issue at stake in this case is whether or not the firearm discovered in the vehicle that DL was driving was something that DL was aware of. In other words, whether or not he constructively possessed the firearm underneath the driver's seat. At the trial level, the magistrate actually found that there was not enough evidence to support a finding that he was aware of the firearm, and she was right. Here, the juvenile court judge made a mistake in determining that the circumstances around this case supported an inference of knowledge. Here, unlike several cases where courts have found constructive possession, there were no additional circumstances beyond proximity to support an inference that DL was aware of the firearm's presence. In the judge's decision in this matter, she focused a great deal on the fact that that the magistrate had found that DL possessed a backpack in the back seat, and determined that if he could constructively possess something that was farther away, that he must also constructively possess something that was closer to him in the vehicle.
Can I stop for 1 second just to clarify? So the magistrate judge found that the state did not prove beyond a reasonable doubt, right?
Correct.
So this wasn't to do with a sufficiency review.
Correct. And
Okay.
I apologize, that was confusing language on my part.
Right.
Yes,
So
so
the magistrate found, didn't prove to me beyond a reasonable doubt. Then this gets appealed to the juvenile court judge.
Correct.
And what was the juvenile court judge's review?
The juvenile court judge's review is de novo, and so she reviews the evidence presented at trial and determines, based on her review of the evidence, whether or not the evidence presented established the case beyond a reasonable doubt.
Okay,
And
and
so-
then our review is sufficiency,
Right,
taken in the light most favorable to the prosecution.
right.
Okay.
And so I want to point to a few facts that I think are really critical and that help highlight why this is not a case where constructive possession was established beyond a reasonable doubt.
Before you go there, and it might be intertwined with my question, I understand your argument with regard to the trial court's discussion in the entry on the backpack. And, it seemed to be a combination of that it was his and access, right? And then that was then inferred into the firearm that was under the seat. But it seems to me that it really wasn't even necessary because a lot of the case law talks about access, that it's within reach. So I don't think that there's any challenge as to whether the firearm was within reach of DL, right?
Correct.
So what I'm saying is the discussion on the backpack, while I understand your argument of the faulty logic in that discussion, in the entry, regardless, you still have to deal with the fact that the firearm was within reach of DL.
Sure.
So,
And
so I know that that's where you're going to go next. And I know that when I read your brief, it seemed to me that furtive movement was one of the things that you were highlighting that was absent in this case, right?
correct.
Are you saying that something more besides being within reach, especially in this case when he's the only one in the vehicle, there's no one else in the vehicle, which is different than some of the other cases, are you saying that that's not sufficient given the circumstances of this case?
Under the circumstances in this case, it's not sufficient.
Okay.
And the reason for that is while DL was the only person who was in the vehicle at the time, this was a borrowed vehicle. There was no evidence put on to establish how long he had been in the vehicle or when the gun had been placed in the vehicle. But based on the circumstances surrounding this particular instance, it is a fair inference that this was not a vehicle that DL had sole access to. He was 17 at the time, but he only had his driver's permit. It was established that he was borrowing the vehicle. And so with those facts in mind, I think we need to look then at whether or not you could reasonably expect that someone who is temporarily borrowing a vehicle would have knowledge of what's beneath the seat. And so in this instance, while he was the only person in the vehicle, this is still very factually similar to State v. Harris in every other way. So in State v. Harris, the court found that there was insufficient evidence to support a finding that the defendant constructively possessed a firearm that was located beneath his seat. In that instance, he was the passenger.
Yeah, there were two people in the car.
Right, there were two people in the car.
Okay, and in this case, we have part of the bag's handle, because I did watch the body cam video, part of the bag's handle was sticking out, right? So isn't that a little bit of a difference too, that there could be a knowledge inferred that he knew that that was there because it was sticking out partially from underneath his own seat and he was the only person in the car?
So I think you can infer that maybe he was aware that there was potentially a bag under the seat, I don't think you can infer that he knew what was inside the bag based on the circumstances in this case. And I would encourage the court to consider any time that you have borrowed a vehicle or rented a vehicle for temporary usage. For example, your car broke down, so you need to borrow a friend's vehicle to go to the store, go to work. And I can speak for myself that I have never, in the times that I've borrowed vehicles, checked beneath the seats. to determine.
That's where I'm getting kind of caught up with the standard of review here, because I can completely understand how the magistrate might have said, okay, I cannot find beyond a reasonable doubt that he's guilty, versus what we're to do here, which is to determine whether there was sufficient evidence. I mean, to me, that's very different, right?
Right.
And so that's where I'm having a hard time saying, trying to figure out if there was sufficient evidence here, because he is alone in the car, there's a handle of the bag sticking out. Is that not good enough for sufficiency?
I think it's not good enough for sufficiency, but even if this court found that maybe that was sufficient, I think that it runs against the manifest weight here, because in this instance, unlike in many other cases, DL did not, although the officer indicated that DL appeared nervous to him, it's very clear that that was kind of a gut feeling and not based on any observable behaviors or anything that DL said.
Well, he had marijuana in the car, too.
Right, he had marijuana in the car, so nervousness could have been related to that. He had a permit, not...
He said he had recently smoked the marijuana, right?
Correct, he
Okay.
did.
Yeah.
And so in this instance, the nervousness, though, is not akin to the nervousness that was demonstrated in, and I'm blanking on one of the, there's another case that talks about nervousness as being a pretty key factor. I believe it was Greenwood. In this instance, though, he was compliant, he was polite, he answered all of the officer's questions. He never reached for anything. There's no allegation that there was furtive movement, and there was no questioning. So if the state wanted to prove their case, the officer certainly could have questioned DL about the alleged firearm to ascertain more information, could have questioned DL about the length of time he was in the vehicle. He didn't. Could have done fingerprints, did not do that. Could have done a DNA swab, did not do that. So there were lots of ways that this case could have been proven, but in the record, all we have is a young person borrowing somebody's car, gets pulled over, and then this thing is discovered underneath the driver's seat, but nothing about his behavior or the circumstances around it would support an inference that this firearm that was found underneath the seat actually belonged to him. And while the strap of the bag was showing, the firearm itself was not. The firearm was zipped in the bag, tucked underneath the seat. And so inferring knowledge of something inside a bag in a vehicle that is not your vehicle is in my mind a stretch. Are there any further questions about the constructive possession? Okay, wonderful.
Okay.
The
You have about 3 minutes left.
Okay, thank you. I also just want to briefly address the issue around receiving stolen property in this case. So the firearm that was found under the driver's seat was allegedly stolen. However, that was not something that was addressed initially at trial, and the judge's finding that it was a stolen firearm is not supported by the record in this case. The state did call...
I have a question on the record on this. So it didn't seem, I reviewed the transcript quickly, and it didn't seem to me that it was argued or challenged by the defense below. It wasn't presented during closing argument, and in fact, there was pretty much no cross, I think, of the owner of this firearm that didn't have rubber bands and didn't have a sight. But do you know, in response to the objections filed by the state, whether it was raised by defense in response to the objections?
No, the objections in this case were solely focused on the issue of constructive possession. That was the basis for the magistrate's decision. And in this instance, I did argue it under plain error because it was something that had not been fully addressed at the trial level. And although in this instance, DL would not have been required to raise this as part of an objection as he was not the objecting party, I
He's
do.
found not guilty.
He was found not
So
guilty.
why would he object?
Correct, exactly. But I do recognize that it wasn't something that was a focus of defense counsel during the trial itself.
Right, and I think you and I might be on the same page on this one, but maybe not, because it seems, while I agree that there would be no reason for him to object, it just wasn't raised at all. Defense focused solely on constructive possession, which obviously would get them a dismissal on all three charges, and didn't, alternatively argue the lack of evidence of, that this firearm itself was stolen, so you can't receive stolen property without determining that it's stolen.
Right. That's correct. That is my reading of it as well. But even with that, I believe that this court can consider it under plain error, and I would say that this is indeed a plain error. It is very clear that this is a deviation from a legal rule in that, as part of RSP, you must prove that the item was in fact stolen. The error was plain and obvious in this instance, and it clearly affected the outcome.
Can you
And
talk
so-
to that, plain and obvious, because, as you know, that's kind of a newer thing.
Sure.
So how is it in this case that it's plain and obvious? That the error is plain and obvious?
I believe that it is plain and obvious because when you review the record, there is no affirmative statement regarding who this gun belonged to or whether or not it was stolen. There were two witnesses that were put on, but neither of them actually indicated that the firearm located underneath the seat was a stolen firearm. So Officer Gertie, had he been asked, could have testified.
But that goes to sufficiency, doesn't it?
So sufficiency is often, there's a line of case law, including a case from the Ohio Supreme Court, which I cited in my brief,
Okay.
that deals with issues of sufficiency being dealt with on plain error, and that sufficiency arguments are almost always going to be preserved for plain error review.
Right, but I think that all precedes this plain and obvious thing. Because I'm going to ask a direct question, and I think I can forecast your answer, but is sufficiency plain and obvious? Is the sufficiency challenge really in and of itself plain and obvious?
I think in this instance, I think in this instance it is because this is a very clear part of the statute. There's not a lot of nuance here. And so when reviewing the record, it is apparent that the court would need to make some sort of finding based on the evidence reviewed that the firearm was stolen. In this case, it wasn't addressed, which is an indication that it wasn't reviewed for that purpose. And I think had the court actually reviewed the entire record to determine whether or not this was a stolen firearm, the error would have been plain. I mean, I think that is plain in the record.
I'm having a hard time with this plain error, because you're conceding that this is a plain error review. This is a situation where the magistrate found not guilty.
Correct.
The state files objections
Yes,
to the judge.
yes.
So Juvenile Rule 40 says that you cannot raise anything on appeal that you basically haven't objected to, right?
Correct.
So why are we reviewing sufficiency under plain error then?
So in this instance, we weren't, as the non-objecting party,
Right?
there was no reason for us to raise an objection.
Right.
And so,
So why would, so.
as opposed to reviewing for sufficiency,
Well, I just don't understand why we would even apply plain error review to somebody who won at the magistrate level and didn't have to object. I mean, it doesn't make any sense to me that you would be required to do the defense would be required to do anything if they get a not guilty from a magistrate. And then they're precluded from, then they have to argue, they have plain error review on appeal. I'm just having a hard time understanding that.
Right. So I,
What would you have done to not have plain error? I mean, what would the defense have had to do?
so I guess I'll walk it back. I think that this can be reviewed under sufficiency. I argued it under plain error to protect and preserve the argument, in part because I think that this is a very plain, open, obvious error.
I know,
but
I know
it's-
that, but I'm just trying to understand what the defense in a situation like this would have to do to avoid a plain error review.
I think that it would have had to have been raised very clearly during the trial. And so because defense counsel didn't raise this as part of his closing argument, that the state failed to establish that the firearm was stolen, that is what shifted me toward arguing this on plain error as opposed to
But the
just.
defense doesn't have to do anything. I mean, technically, below, and if they get a not guilty, I mean, we're going to penalize them for not raising a specific argument?
I will happily take a lower
I mean,
state.
I'm trying to figure out why you're conceding that this would be plain error review under these circumstances.
I had, and I think this is one of the challenges with the way that the juvenile court is set up with the way objections work. And so I had considered it from sort of the point of view of what we are required to raise during trial and what it would potentially be had this been a trial where the magistrate, if this had been an adult trial at municipal level, would that argument have been considered not to have been raised, was my concern. However, I do agree full-heartedly that the burden shouldn't be increased on the defense when we have won the trial and then are objecting up to the judge.
I think where you were going with that is if this was an adult trial and there was no Rule 29 and there was no sufficiency argument at closing, that we would, I think, be reviewing that under plain error on appeal.
Although there was a sufficient, so I might have
Sufficiency on the RSP.
as the basis. So, sorry, I just want to, I know
That's
I'm out of
okay.
time
Look,
here.
I
I wasn't
appreciate you
trying to,
answering.
I'm trying to understand, this is an interesting situation where you have a not guilty by a magistrate, the state appeals it to the juvenile court judge. And so, you know, why a defendant below would have to raise specific arguments about why they're not guilty, and they get a not guilty, and then they're precluded from having regular sufficiency review here is just what I'm trying to understand. That's
Right.
all.
No, I appreciate that. And, you know, I think that perhaps it was a mistake on my part, and I will own that. And I think sufficiency is perfectly appropriate. And I would ask that the,
Counsel, I'll give you a minute to, whatever it was that you wanted to present. If you
Okay.
want to go back, okay? But we appreciate you responding to our questions.
so regarding regardless of whether it's reviewed under sufficiency or plain error, it is clear in the record that it was not established that the firearm that was located under the seat was a stolen firearm, and certainly not established that if DL did have knowledge, which we obviously oppose, that he would have known that it was stolen. And so we would ask that the RSP be reversed and discharged as being not supported by sufficient evidence. We would also ask that DL, CCW, and other charges also be reversed and discharged or remanded back down for a new trial. Thank you very much.
Thank you. And I preserved your 3 minutes. Counsel, I just want to let you know, I preserved your 3 minutes.
Oh, thank you.
Okay.
Thank you, and may it please the court.
Good morning.
Good morning. Hope everyone had a good weekend. Opposing counsel and I were actually speaking about this beforehand. We were here just last week in front of, I think Judge Zayas was the only judge on that panel,
Okay.
where we dealt with a similar issue involving this concept of plain review and error. Although it was a different circumstances, we had similar questions regarding juvenile proceedings and the nature of plain error review when this kind of the judge steps in between the magistrate and this court for the purposes of determining what this court's role is. I think it's been conceded, although perhaps maybe mistakenly, as Judge Krause, as you were saying, for the, or maybe not saying, but questioning in regards to the particular error. I want to address that first while it's clear on everyone's mind. First, what I'd like to say that I do read opposing counsel's motion as having conceded that as plain error review. I don't believe that that's a mistake, because I do think that they're limited to plain error based on the nature of the proceedings below. And I want to be clear that there's a question from you, Judge Zayas, about there was maybe some reference to like it being plain and obvious, this error being plain and obvious. I want to be clear that the error alleged on appeal is not the sufficiency of an element of the phrase, like the state failing to present sufficient evidence. The error alleged on appeal here, as I read it, is the error of a court to conduct a proper de novo review. So, Judge Zayas, you had asked a question about what, the presumptions that we have, and we're looking at the record below. As I see it, when we're looking at what is plain and obvious, we're not reviewing the whole, obviously the court is bound to review the whole record, but the error that we're looking for that has to be plain and obvious below has to be that the court plainly erred by failing to conduct a proper de novo review. And I don't think there's anything in the record that would indicate that the court failed to conduct that proper de novo review, because I do think that there's, and now we're getting into the confusing aspect of it, sufficient evidence as to all the aspects. I think the first thing that I would state, and I think this relies into what you were talking about, Judge Krause, is that this was never raised at any point below, this idea that as I understand the argument of the defense, is that the particular testimony of one of the witnesses should be interpreted to mean something that was never raised by any of the parties.
Well, let's work with this.
Sure.
The testimony that the gun was stolen was just Mr. Parker got on the stand and said, yeah, it looks like my gun. And he's like not even from Hamilton County. He's like from some other county, right?
I believe so.
Okay. Looks like my gun, but it looks a little different. Mm-hmm. Was there any additional evidence connecting the gun at trial to the gun that was stolen besides that?
I would take objection to the way, and I think you're doing exactly what opposing counsel is doing, which is kind of importing your own interpretation of the testimony based on what is only in the transcript.
What was only in the transcript?
Well, you're reading from the words, like, for example, I guess
That's all I have.
I understand that, but what I mean is, like, if I were to say, for example, on a transcript, if I were to be asked the question, so you left your house that night, and I answered like, oh yeah, I left my children at home so I could go on a date. That could be read on
He
transcript.
said it is
as-
different. These rubber bands weren't on there, nor this. I'm assuming this is a laser sight on there, but other than that, it looks like my handgun.
Yeah.
Okay.
The thing there being the modified, the thing that was the changes were made to.
Or what
which
about
is-
like a serial number or something?
Couldn't they have matched the guns somehow, separate and apart?
They could have, yes.
And they didn't do that.
Correct.
So that's like that gun theoretically matches every single gun by that manufacturer of that same model in the absence of something that specifically identifies it, like a serial number or a gun casing bullet, right?
I would think that would be a correct interpretation of the evidence. What I am stating is that for the purpose of sufficiency, not touching the plain error review.
Yeah.
And I do want to get to that, Your Honor.
Please do.
I think that now we're getting into a reasonable interpretation of the evidence, and especially when weighed in the light most favorable to the state. We're talking about an individual who said, I had a Taurus 9mm handgun, and a Taurus 9mm handgun was referred to here. As I read the testimony of the witness, especially with the follow-up questions about the modifications, is that the thing to be modified was his handgun. It does look like his handgun. The reason it might not bear the reason that there'd be any differences, I think what the witness was trying to make clear is this individual has modified my handgun. And so the looks like there is that explaining the differences of what, that were between what he lost, what was stolen from him, and the
there's no-
handgun that was presented.
Would you agree that there was no other evidence that ties DL to that gun other than the testimony of this individual with regard to a firearm that had been stolen? So this isn't a case where someone looks out the window and sees somebody and notices that they're somewhere they shouldn't be, and then later notices something's missing, and then comes to court and says, that looks like the thing that I used to have that I no longer have. This is not this case. There's nothing but this individual saying, I have a gun, looks like that, this one has a sight, this one has rubber bands, and mine was stolen.
I mean, I think inferred through the testimony as well was the time frame of when it was stolen and when the gun was retrieved is additional evidence there. Obviously, at least with the victim's testimony of it having been stolen, it was recovered within an appreciable time frame for where it could have been possible, as well as testifying that it did appear to be his firearm. I mean, I don't want to get.
But you're saying we don't look at sufficiency.
Correct.
That's what you're saying?
Correct.
Okay, so what are we doing?
And I believe what this court has to do is look and determine whether or not the court conducted a proper de novo review of all of the elements. And your question, and I want to answer it. There was I believe your question to opposing counsel is, well, what do we do if we win? How do we know?
What does the defendant do to preserve any sufficiency argument on appeal in a juvenile court case?
As I understand, when it comes to plain error review and as I understand the juvenile rules for the purposes of preserving something other than plain error review for appeal, I believe it has to be raised at that lower level before the trial court. And how that is raised, I think, is going to depend on the specific case. What we don't have here is an issue where the magistrate said, for example, what the magistrate said in her decision was, I don't believe the state has met its burden to proving a reasonable doubt, an element beyond the reasonable doubt, and did not touch any of the other elements. At least that's what I recall. So the magistrate never made a legal conclusion as it went to the whether or not that stolen firearm was in fact.
She just
proven to
thought
be
he didn't
stolen.
know it was in the car.
She didn't. To be frank, she didn't
Basically.
have to get there because she had already
Yeah.
had something that defeated the
He
state's
didn't
case.
constructively possess it, therefore
Correct.
we're done.
What I think the burden there is, in order to preserve a proper sufficiency or standard weight, whatever it is for appeal, I think one of two things needs to happen, or perhaps both things need to happen. The juvenile rules allow for a party to request, either party, successful or not, to request for findings of fact and conclusions of law. In other words, you say to the magistrate, I know you didn't make a determination because your determination as to one element obfuscated the need, but we need a determination as to the findings of fact and conclusions of law as it relates to these other elements. And they could have done that, and they didn't. And then another thing they could have done that I think would have properly preserved it is to raise at any point and say, hey, based on our interpretation of the evidence, we don't think that the state has proven either this element that the magistrate found or that the firearm was stolen, and they never did
So
anything.
they have a burden to, instead of just saying, didn't do it, they have to give precise arguments in order to preserve this?
I don't know that they have to give precise arguments, but I do think that at some point it should have been, in other words, and I think this goes to my frustration about the interpretation of what the witness said in this case. At no point, whether it was through any of the trial counsel, whether it was in closing argument, whether it was the magistrate or the judge, anyone who viewed the witness's testimony, no one at any point interpreted his testimony to be how Your Honor phrased it, which is, oh, this just looks like my gun. That was the point.
I'm not interpreting. I read his testimony, and that's what he said.
What I'm arguing is that pronouncing the words in a certain frame, I think, imports onto it a certain type of interpretation, which I think you more easily get in actually viewing the testimony than you do from just reading
But
it
it's
in a transcript.
but it's the state's burden, so I don't think that we can say that the defendant has any burden whatsoever, right? To
In
do
regards
anything. To do anything below in order
to preserve.
to get a not guilty. I mean, certainly if they're found guilty, they've got things they have to do.
Sure.
But if they're found not guilty, I'm just looking at the juvenile rule, And, it talks about a party shall not assign as error on appeal the court's adoption of any factual finding or legal conclusion, unless the party has objected to that finding or legal conclusion. Well, the court didn't adopt any factual findings or legal conclusions made by the magistrate. Anyway.
And I think that, and I don't think opposing counsel would disagree with me on this, when it comes to findings of fact or conclusions of law that a party specifically needs to oppose, I think they have to ask for that either from the magistrate. I think the rules require that, because failure to ask for those findings of fact and conclusions of law in order to raise a proper objection to the ones that you want to object to waives all but plain error on appeal. So I understand, I think you do need to make,
So you're found not guilty by the magistrate, and then you have to ask for findings of fact and conclusions of law so that you can potentially object to something
I think
the
if
juvenile court judge.
I believe if the state is saying, we're appealing this to the trial court judge, we think that we've met this element, and that's the only thing that we're raising, because at this point, as far as we see it, this is the only issue before the magistrate. So if you disagree with that as the defendant, and you believe, no, we have other issues that we need to handle, you do need to raise them, because otherwise it puts us in this position of having to go through this review of evidence in such a way. And
Are you saying that it should have been raised in the responsive brief by defense counsel to the objections?
I think,
or elsewhere?
I think at a minimum, once the state had filed their objection, if there was anything that the defendant wishes to preserve his appeal, any issue for appeal for, it's on him to file findings of fact or conclusions of law. Else, I think it's on him to point to something in the transcript that the magistrate said, or at the very minimum, raise it in some manner, whether that's through oral or responding in their objection, to the trial court judge and say, at a minimum, I think what we would look for is something to the fact of, Judge, we just want to be clear, the trial court, found, we don't think, they found as to all the elements. We understand the magistrate stopped at the one element they were supposed to, but we don't think they met it as to these other ones. I think another reason it's incumbent upon the defendant to do that is because they have to know that judge is going to be conducting a de novo review of all the elements. And that's generally why, as I understand it, parties will include and say, which I believe it appears in the state's objection, we've met all of the elements. If they disagreed with the state's suggestion that in their objection and said, where the state said, we've met all the elements, if they disagreed with that, it is incumbent upon them to raise that once it goes up on de novo review. Otherwise, this court is left in the unfortunate position of having to have this argument, I suppose.
Did you cite any case law to support what you, I think it's an interesting argument. Was there cases that you cited in your brief?
As to the plain error,
Just on kind of what the obligation is on a defendant.
Because it was conceded that it was plain error, we didn't address it. I'm addressing it for the first time here before this court, my understanding of the law. But
Thank you.
And I'm not sure that I understand fully what you're sharing with us with regard to the plain and obvious aspect of the plain error review in this case, because you're relating that back to whether the trial court conducted a proper de novo review.
as I understand,
And this is, if we were in an adult proceeding and there was no objections, right? And it wasn't raised by defense counsel, then we're doing plain error review and its sufficiency. And we've had these cases, we've had sufficiency on plain error review multiple times in this court. I don't know that we've had any since the plain and obvious requirement. But, we were looking at it as sufficiency.
I think I wanted to be clear
So
about.
why would it be any different for a juvenile proceeding, and now it's about the objections now changing the nature of how we're going to be reviewing plain error on the sufficiency?
When I first came up here, I think what I was intending to do was to frame the argument about what that action, we're talking about plain error, what the error was. The appellant's brief notes the error, as it's alleging on appeal, as that the trial court committed plain error by failing to consider whether the state presented enough evidence to establish every element of receiving stolen property. That failing to consider, as I see it, is the error. I think that's what I was saying. Not the sufficiency, but the failure of the court to conduct a proper consideration of the evidence. Generally, that issue, whether or not the court failed to consider a proper element of the law, is fairly easy. Unless the record dictates otherwise, this court presumes the presumption of presumes regularity in the proceedings. But because I think in reality what they want to do is argue sufficiency or weight, that's what their argument is mainly focused towards, is the sufficiency. But the point I was trying to make was, realistically, the error that they're alleging, this failure of the trial court to consider every element, I think the record demonstrates this court should presume the regularity of the proceedings, and that the court did conduct a de novo review.
I recognize that you've not been able to get to your argument with regard to the carrying concealed weapon with regard to constructive possession. If you'd like, I can give you a minute to address that.
If that would be okay. I mean, all I'll say is that as I stood back there, it seems to me that the argument being made by opposing counsel was more akin to a closing argument, which is, here are all of the facts that would otherwise support the determination of the trier of fact, and trying to find a individual reason for each of those facts that lead to the determination of the trier of fact in order to explain them away.
It's more of a manifest weight argument.
Correct. But I think either under a manifest weight or sufficiency of the evidence, taking all of the evidence together, one can come to the determination that the trier of fact found, which is, in this case, the defendant did have constructive possession. I don't believe it was based merely on proximity, as this court had pointed out in questioning, distinguishing factors from other cases. He was the only individual in the car. I think his actions both in the car when he was driving away from the police officers and while talking with the officers indicated that he was nervous. And the handle of the strap of the firearm, or of the bag, was, as I see it, clearly visible. He was using the car for his own transportation. He had other items within the car. All of these, I understand, could have possible innocuous explanations, but taken together, I think, especially when weighed in the light most favorable to the prosecution, would lead to the conclusion that he was driving the car for his own, for his own reasons. He knew about the bag that was clearly visible on the seat. He knew about the firearm, and he was in constructive possession of that firearm based upon, his knowledge of that bag, proximity to that bag, and easy access to that firearm. If otherwise I'm out of time, then I have nothing else. Thank
All
you.
right, thank you. Thank you for your argument.
I will try to keep it very brief. I know that we are well over time at this point. There are just a couple of things that I want to address. I want to move back to this issue between plain error and plain error versus sufficiency review under the circumstances. Regarding what the appropriate approach is, I disagree full-heartedly with opposing counsel regarding the need to file a request for findings of fact and conclusions of law under the circumstances of this case. I don't think that was at all necessary. I will note that defense counsel did raise a criminal rule 29 motion to dismiss at the close of the state's case. And so that too would have preserved any argument regarding sufficiency.
Well, they didn't
And-
articulate anything. They just raised it and didn't say anything.
That's
There was nothing specific other than Rule 29.
right. So they raised the Rule 29. They addressed some things in closing argument, but they did not specifically address this particular argument. And so regarding the plain error or sufficiency, either way, had the court conducted a proper de novo review as it's required to do, it would have found that there was no evidence to support a determination that the firearm was stolen. And in this instance, the juvenile court did not address that at all in its decision on this matter. Once she determined that she believed that there was constructive possession, that was the end of the analysis.
So it seems to me you're saying the evidence was not sufficient, and that is plain and obvious.
I am, again, based on this, under the circumstances of this case, yes. There are other cases where there might be more nuanced questions that are raised regarding a particular statute and what needs to be proved for that statute. Under this statute, the elements are incredibly clear, and the evidence in this case is such that if the judge had done a de novo review, as she was required to do, she would have realized that an essential element had not been established. If there are no other questions, I will close with that. Thank you very much, Your Honors. We would ask that we have this case reversed and discharged. I appreciate your time.
Thank you.
Thank you.
Thank you both for your arguments this morning. Thank you for doing the best possible. I know that some of the questions were kind of unexpected, so we really appreciate both of you always coming here and putting your best foot forward. Wish you both a great afternoon. We'll take the matter under submission, issue timely decision, and that concludes the proceedings for today. Thank you.
All rise. The Court of Appeals First Appeal District of Ohio is now adjourned.
Marilyn, is that not yours? Is that the timer? Mrs. Dahl's there?